everybody. Welcome. Happy Friday night, TGIF. How are y'all? Welcome. We're going to do 2 hours tonight. So the first hour, we're going to talk about the Vallow Daybell case, about a couple of hearings that happened today and yesterday. We're going to talk about the run-up to trial and what some of the possibilities are for the judge perhaps ruling on the motions. And we're going to talk about, and I'm going to answer questions. In the second hour, we're going to talk about Murdaugh. As you all know, if you've been following the Murdaugh trial, Alec Murdaugh was on the stand yesterday and today. And today he faced some pretty withering cross-examination. But there were a lot of comments about whether people thought that the cross-examination was effective or not. So we're going to talk all about that. So I'm just got 103 people in chat already. I'm going to give people a little bit of time to catch up. While I'm doing that, while we're doing that, I want to remind everybody, please subscribe if you haven't. Please subscribe to my newsletter, which comes out. It's been fairly infrequently lately because there hasn't been a lot to report on to go really in depth in, and that's what we use the newsletter for. But I guarantee that as we heat up for the trial, it's going to be coming out more frequently. I also want to remind everybody to hit that notification bell to get notification when we go live, because as we get closer to the Daybell case, I expect there are going to be some more impromptu kinds of lives that are going to come out about the trial. So the trial starts in April. I'm going to be attending. I'm going to be trying my best to give you updates from the courtroom. That's going to be especially important if Judge Boyce continues his camera ban. So we're going to talk about that too. And now would probably be a good time to talk about that. Nate Eaton and the folks from East Idaho News have sent a letter to Judge Boyce asking him to reconsider his decision not to allow cameras for the trial. I think that with the amount of pressure that has come to play on Judge Boyce and his acknowledging what a large, gosh, you'd think I had not been working all day. My brain is just not catching up yet. Especially understanding the pressure that's going to be put on the Ada County Courthouse, I think that there is a better chance at this point that he may relent and allow cameras for the trial. I understand that lots of folks have reached out to contact him, including members of the media like Nate, including folks who people who are related to the case, family members asking for the judge to reconsider his position because not being able to see the case is going to create a lot of hardship for them. So I suspect that we may be tipping over into more likely than not that he will allow the live stream, but I don't know yet. Everybody's keeping it pretty quiet, and right now, there are no cameras being allowed in the courtroom for any of the hearings in Fremont County, in St. Anthony. And so we will just have to wait to find out whether he's going to back away from his original order. And while we're letting folks catch up, wow, 172 of y'all in chat. Thank you for joining us. I always appreciate it. I recognize that you could be spending your Friday night a lot of other places. I want to point out up here that these are some of the squares that we're working on for our True Crime Quilt Guild. If you haven't joined us yet, please do. The information is in our show notes down below. Please join us. It's not too late to catch up. And even if you are a beginner, I have some um, instructional videos on the website, and I walk you through each one of these, creating each one of these squares. They are not as complicated or as challenging as they might look, and even a beginner could tackle these. So I'm going to be releasing the most recent instructional video, I hope tomorrow. I'm going to try and get it edited, and we'll be moving forward. So, what's been going on in the Vallow and Daybell case? Well, first of all, there was a pretrial conference today. Yesterday, there was a hearing that was primarily sealed, and the reason for that was because they were, again, discussing issues having to do with jury selection, having to do with information that would be given to the jury as jurors appear for jury duty. And the court has been cautious about making sure that we're not further compromising the jury pool by putting information out that should only be communicated to the potential jurors. So yesterday's hearing was mostly in chambers and a sealed proceeding. But today we had a pretrial conference. The judge also took up a couple of motions that are in front of the court. And so they started out with the pretrial conference. At the pretrial conference, Jim Archibald, Lori Vallow's attorney, said they were ready for trial. The state said they were ready for trial. And John Pryor said, not ready for trial. That rolled over into John Pryor's most recent motion. His most recent motion is either to dismiss the indictment or to take the death penalty off of the table because of discovery violations. Once again, discovery is always an issue in every case. And it shouldn't be, but it is. Now, we understand that there was this huge volume of discovery. It is the obligation of the state to provide to the defense everything they have or could be expected to get pre-trial. Anything having to do with the investigation has to be turned over to the defense. And that means anything that would come from an investigative agency like the FBI, the state police, any of those investigative agencies. So there are two issues that have come up recently. First of all, according to the response to John Pryor's latest motion, the state contacted John Pryor. Earlier this year, there was a discussion about consumptive DNA. That is where the sample was so small that it would be consumed in the process of the testing. So they kind of went round and round for a while. They finally agreed to a process for this testing to happen. And the state sent the first thing that happened was that they didn't reach an agreement about the consumptive DNA until Lori was competent again. So that didn't happen until April because the state wasn't willing to go forward without Lori's participation, because this is a one-shot deal. I mean, if John Pryor had agreed, yes, we'll allow this consumptive DNA, and Lori's attorneys had come back and said, wait a minute, we didn't get a say on what was going to happen with that DNA, that could create a problem. So the next thing that happened was they all came to an agreement, and the state sent the information off to the state lab. State labs are notoriously backlogged, notoriously slow, notoriously understaffed, and often notoriously under-equipped. So we got to a hearing in late November where John Pryor complained that he still didn't have the results of that consumptive DNA. And so the state said, we'll get on the lab and we'll figure out what's going on. Well, right around Christmas time, might have even been Christmas Eve or maybe the day after Christmas, the state contacted John Pryor and contacted both attorneys and said, the lab has discovered, as they've been processing to pull this DNA, they've been processing the samples, in the duct tape that they were working from, they've discovered 2 more hairs. And they're not sure that they can even lift DNA from the hairs, but if they do, it will be fully consumed. So we're in another consumptive DNA situation. So John Pryor, rightfully so, says it is possible that those samples could exculpate my client, could prove that my client is not guilty. And so I need those samples. I need to have those samples tested. And the court said, you're right, Mr. Pryor, you're entitled to those, and you're entitled to be able to evaluate the evidence and figure out how to go forward. So the state discovered that the lab wasn't going to be able to produce samples of these items, and so went to an outside lab in California that has a much more sophisticated process and reportedly can process the samples faster. So they guaranteed that they or assured the DA that they would have the samples back in 3 weeks. So here we are at the 3-week point, and Pryor is going to court and saying, I still don't have those samples. I don't know whether whose hairs those are, whether they exculpate my client. I don't know whether they are important or not. And I don't have time to have my own expert now take a look at all the raw data and decide whether or not that the DNA is of any value. So he has filed a motion to sever the trials, and the judge had indicated at one point that if the state didn't take aggressive action to get this testing done and get the DNA back to Pryor, that he might sever the cases and allow Pryor more time to investigate his case. He would sever the cases because Lori has not waived her speedy trial right, and her trial would have to go forward. Now, neither the judge nor the prosecution really want the cases severed. So I'm not sure there's a very large chance that that will happen, but it is in the back of the judge's mind, at least, because he said it out loud in court, that it was a possibility. So John Pryor has jumped on that, and now he's like, yeah, we have to sever. So he's got an outstanding motion to sever. He's also filed a motion saying, Judge, the proper punishment for this DNA violation, this discovery violation, the proper remedy for that is for you to dismiss the case, dismiss the indictment, or in the alternative, to take death off the table. I don't think that goes anywhere. I don't think there's any precedent for it. I don't really think that it goes anywhere. I don't think that it will fly. The judge is going to say, no, I'm not going to modify or throw out the indictment. I'm not going to throw out the death penalty notice. I'm not going to do any of those things. And I think ultimately that was done in order to set themselves up for appeal. The other one, the motion to sever, I think there's a little more danger there. If the judge finds that the prosecution has knowingly not provided the evidence that they were supposed to provide, then I think the judge could, as a remedy, give Pryor more time to prepare and could sever the cases and set Chads out. I think that is very problematic for the prosecution because they don't want to try this case twice. Not only is it an issue of a tremendous cost and a tremendous amount of work to try the case twice, but the defense then gets a preview of the state's case. And when that happens, then Pryor is going to be able to get to prepare for the case in a way that he would not have been able to if the cases went together. So I don't think the prosecution wants to do that. And I think they're going to do everything they can to try and make that happen. Now, the other issue is late discovery being provided to John Pryor. So John Pryor is complaining that the state recently dropped a bunch of late discovery on him, stuff they had and didn't provide. So there is no obligation for the state to present the discovery in a particular form or format. There is no obligation for the prosecution to provide everything in a nice little organized heap. Now, it's kind of professional courtesy to make sure that you've got all the applicable files in the right place, but it's not required. In discovery, civil discovery, they're notorious for handing over thousands of files, and the important piece of paper is buried in those thousands of files somewhere in thousands of pages of discovery. And I think that is possible in criminal cases as well. Yes, they have an obligation to turn everything over, but they don't have an obligation to point it out with red circles yelling, here, 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 here's the important stuff. That is up to the defense to sit down and go through all that information and figure out what's important and what's not. It really, the discovery that they're sent, they have to look at it as this is raw data that I have to process. So this is what Pryor is complaining about. But in any criminal case, the defense is always free, and I know that this has been in every discovery motion that and response that the prosecution has provided since day one. In every case, the defense is free to go to the office of the prosecution and look through every file. Now, I guarantee you, I have done this before, and I guarantee that if I were involved in a case of this magnitude, I would have called, a year ago, would have called the prosecutor's office and said, hi there, I'm going to come over, I'm going to bring my own hard drives, I'm going to come over, I'm going to bring my own laptop, my own hard drives, and I am going to come over and I'm going to view every piece of evidence, every bite of evidence that you have about this case. And it's probably going to take me about a month, so I'll be happy to be taking up space in your office for about a month. Now, the prosecution is not going to want a defense attorney parked in their conference room for a month, so they're going to figure out an alternative. But what it does do is it gives the defense attorney the opportunity to sit down with all of the information and figure out what you have and what you don't have. That is the defense responsibility. Yes, it is the responsibility of the prosecution to turn everything over, but it is the responsibility of the defense to check and double check to make sure that gets done. So in some regard, John Pryor is at fault as well because he hasn't been over there and looked at what they have. He has taken at face value what they have sent him. So one of the things that came up recently was the prosecution, in doing their trial preparation, discovered that they had not sent all of the information associated with the tips. They'd sent him a digest of the tips, but they hadn't sent each individual tip of like 500 tips that came in on the tip line. And so they got all that information from the FBI, which was the organization that was compiling the tips, and they gave it to John Pryor. That's the 1,188 pages of discovery he got a couple weeks ago. Now, had John Pryor thought that one of those tips could have been important information that it could be exculpatory information, he should have gone back and said, where are the tips? I don't want just the digest. I want all the raw data. He didn't do that. He could have gone over to their office and said, I want to see all those tips. I want to look through all of them and see if I agree that there's nothing of any value in them. He didn't do that. So I think on that issue, on the issue of this late discovery that's coming up, I think he loses on that, because I think at any given time, he could have gone and gotten them. That's different from this DNA evidence. I have this one pesky hair that's hanging in my face. It's different from the new DNA information, because there would have been no way for him to get that information without the prosecution processing it. He also brings up the issue that there is, they call it Faro. It's a laser assisted measuring system that can create a 3D rendering of a location. You've seen it used in the Murdaugh case, if you're watching that. And he complained that he got a face sheet, but he never got the whole file. Well, he would have known that had he gone over and looked through all the DA's discovery, but he didn't do that. So I'm not sure that he gets a lot of traction by saying, I keep having to file motions to compel to get all this stuff. I don't know that he gets all that traction. I think that if he had gone over to the DA's office and said, hi, I'm here and I want to see the Faro data, and I brought my own hard drive so that I can download it all, and I'll just be waiting around until I get it, he would have probably had better luck than filing the 900th motion to compel. But that didn't happen. So I think he loses on these discovery matters and about late discovery. I don't think the judge is going to order him to. I don't think the judge is going to order the case to be the indictment. Sorry, I don't think that the court is going to dismiss the indictment or take death off the table, because I don't see those as appropriate remedies for the discovery violations. But I think it is possible that if Pryor can make a cogent enough argument about the late DNA, the new consumptive DNA, I think there's a possibility the judge might sever the cases, which is the prosecution's biggest nightmare. So I don't know whether the prosecution is going to be able to come up with some sort of a resolution, but if I were them, I would be hot on the trail of that California lab and getting that information back as soon as possible. The other thing is that the judge has set a discovery deadline, which I think is this next week. So we haven't gotten to the discovery deadline yet, and I think that may have something to do with the judge's decisions. Ultimately, Judge Boyce did what Judge Boyce usually does, and he took it under advisement, He asked the DA to provide him with information about how soon the DNA was going to be available, because that would contribute to his decision. And he took it all under advisement and said he would issue a written decision. I suspect that right after the discovery deadline, we will get a decision. As I say, I don't think he will dismiss the indictment or take death off the table as a consequence of him not providing the discovery, but I do think that he may sever the cases. And I think that is going to be something that the prosecution is going to fight, and they are going to do everything they can to keep that from happening. So we're right about the half-hour mark. I know that there's lots of people who want to ask questions about what's gone on this last week. So let's take some Vallow questions, please. Vallow Daybell questions. Go ahead and put them in the chat. Start out with the word questions so that it makes it easy for our mods to find it. And in the second hour, we will talk about Murdaugh, his getting on the stand and testifying, and what you all think about what's been going on in that trial. So exciting. We're going to be here for 2 hours tonight. So grab your favorite beverage, red wine for me tonight. I hope that all of you who are in the path of a lot of very icy cold weather are staying safe and warm tonight, and keeping everyone there in my thoughts. It has been cold here in Idaho, but in Boise, but we have not had a lot of snow. We had a little dusting a day or so ago, and now it's all melted off, and our daytime temperatures are getting above freezing. Nighttime, still cold. Hi, Mary. Question: were Chad or Lori in court yesterday? They both were in court yesterday, and they took up the pretrial and some other issue that Archibald brought, and they offered to have her stay while they heard the motions that Chad's lawyer had brought. So they were both in the courtroom for the whole time. Every once in a while, we've seen it where the judge has said, we're done with Chad's part of this and he can go, or vice versa. But the last couple times, the judge has permitted them both to stay in the courtroom. I understand from Nate Eaton, who was in the courtroom in Fremont County, that there was an exchange of glances and perhaps a mouthing of words between Lori and Chad, but that was all. We are still hearing rumors of the potential for a plea agreement, but there's no way to know at this point whether those talks are continuing or whether that's a dead issue at this point. So we'll have to wait to see. Dr. Molly, will Lori and Chad's lawyers be working together during the trial? How does that work? Well, it really depends on the theory of the case. I've had cases where I've worked closely with a co-defendant's lawyer because we both really had the same theory of the case. We both really were presenting the same evidence and the same information. It is vastly different if you have a case like this one where it appears that there's going to be some finger pointing at one another. In that case, I don't think you'll see a lot of work together or a lot of cooperation between the two lawyers. So generally what happens is the prosecution puts on their case. So as you saw in the Murdaugh case, the prosecution will call witnesses. The witnesses will be questioned by the prosecution. The defense will have an opportunity to cross-examine. And in this case, in a case where you have two co-defendants, each of the co-defendants' attorneys will be allowed to cross-examine the witness. Usually the one who starts first sort of gets all of the juicy stuff, and then the second one kind of bats cleanup. They may agree to take turns doing that, who goes first, who goes second, um, or the judge may decide who goes first and who goes second. So that then what will happen is the prosecution rests and the defense will present their case. In that case, Lori's attorney will present their witnesses, and both the prosecution and the other defense attorney will be able to cross-examine, and then the other, say Chad's attorney, will present his witnesses, and both the prosecution and Lori's attorneys will be able to cross-examine. Each one gets to make an opening statement. Each one gets to make a closing argument. So it is a fairly autonomous process, unless the two attorneys, out of choice, decide to put on a sort of unified defense. And even in that case, each attorney would be asking questions and cross-examining. So good question, but that's what you can expect. Why have Lori and Chad been wearing ankle shackles lately? They haven't had those before. Cork. Imagine that, a bottle that didn't screw off. Good question, Kathleen. Lori and Chad have been wearing ankle shackles. It really, hello. The sheriff's department determines the level of security for a prisoner. So we don't know what's going on under their clothes, because there are devices that go under their clothing that could possibly be in play. It really depends on the sheriff's office, the number of deputies that they have available to escort, the number of deputies they have available to be present in the courtroom, the other devices that might be employed. All of those things sort of come into play. It really is up to the sheriff to make that determination. So I don't really know why they've had them both in ankle shackles lately. It's not really all that unusual. Usually it is ankle shackles or belly chains. I think the belly chains, that's not a great look. And I think that the ankle shackles are a little more subtle because they're under the table and you only really notice them when the person's walking around and they're not up and walking that much. So it really is the preference of the sheriff's department that is tasked with making sure that the courtroom's secure and that the prisoners are secure. Good questions. Lori girl, thank you, by the way, for your donation. I want to mention this now that it's come up. I've seen quite a few Super Chat donations come through tonight, and I want to tell you how much we appreciate them. Every donation, every time you Super Chat or send a PayPal donation, and the PayPal link is in the show notes, every time those donations go directly to our moderators. I appreciate so much that our moderators are available to help me, and when I text them and say, hey, can we do 2 hours tonight? They're all like, yeah, we're ready. So I appreciate so much that they are available. And so I have said from the beginning, any of those donations go to them. Once a month, I tally them all up and they get a check. I want to encourage you to continue to donate because I really think it's made a huge difference for a couple of our mods. It's been incredibly helpful, and they appreciate it, and they deserve it. More importantly, they deserve it. So now, do we have any idea what Tuesday's hearing is about? We know that it is another status conference. I think it has to do with the DNA. I think the judge wants to know what the status of the DNA at the California lab is before he makes a decision on whether or not to sever the cases. And he did make a comment, by the way, another reason we may want cameras in the courtroom. During the hearing that we had yesterday, the prosecution's microphone wasn't on. So you can hear all of the defense and the judge, but you can't hear the prosecution. I hear that there's a new video and that the court has somehow fixed it, but it is a problem. But the judge did say to the prosecution that he was very interested in knowing the status of the DNA from the California lab before he made a decision on the motion to sever. So I suspect that might be what is going to come up. I think the status conference is for him to get that information and potentially to issue a decision. Don't know for sure, but I'm sure we'll find out. Hi, Jennifer M. Question. If the judge grants Chad's motion to sever the trials, do you think Lori will give up her right to a speedy trial just so she can sit in the courtroom with Chad? Nope, I don't. For whatever reason, she decided early on that she was not going to waive her speedy trial right. I happen to think it has something to do with her prior attorney saying, whatever you do, don't ever, ever, ever agree to waive your speedy trial. I don't know for sure. I think that it's very clear from everything we have heard from Lori and her counsel that Lori absolutely believes that she will be exonerated. She absolutely believes that this is only a trial for her and that God will eventually release her. And so I think that being the case, I think that she will press right to the end to get her day in court, that she very much wants her trial. And I think probably the judge is going to give it to her. Well, I think certainly he's going to give it to her. And I just don't think her sitting next to Chad in the courtroom is that important to her. Hello, Gail Johnson. If the new possible DNA discovery hairs were just now found, how is it that the prosecution's fault? Isn't the defense allowed to view the evidence? Well, yes, but the defense isn't allowed to analyze the evidence and look at it under a microscope and determine whether their hairs is caught in the tape or not, in the duct tape. They are entitled to look at the reports, the photos, all of that, but they're not really, I mean, they could go to the evidence locker and ask to see the evidence, but they're not permitted to handle it and potentially contaminate it and to process it in a scientific way. That's the job of a laboratory, either a private laboratory or the state lab. So the possible new DNA is not the prosecution's fault. It's not. The lab notified them that they found these new hairs. They notified the defense. They've gone out of their way to find a private lab that can process these hairs. To be honest, we don't even know whether there's recoverable DNA in those hairs. The state lab was confused or conflicted about whether or not there was DNA that could be discovered from those hairs. So they've sent them out to a lab that says, yeah, they think they can get DNA out of them, but we don't know. We don't know what the value of that is. We don't know what the depth of that is. I mean, can they identify this DNA matches the profile of Lori Vallow or Alex Cox, or can they only say it's DNA from a female, or it's DNA that can't be excluded as Tylee? I mean, we don't know what if any evidentiary value that DNA has. On the other hand, could it be Chad's DNA? And suddenly Chad, who said I was never there when it happened, gets included in as somebody who was on the scene at the time that JJ died. The hairs were found in the duct tape that wrapped JJ, so we have to assume that it has something that they were deposited there by somebody who participated in wrapping his body in the tape. So the newly discovered DNA is not necessarily the prosecution's fault. That doesn't mean that Pryor doesn't get to view the evidence to make sure that it isn't something that exculpates his client, and it doesn't mean that he isn't entitled to more time to process that evidence. But it also doesn't mean that he's necessarily entitled to more time. It's going to depend on what the judge decides and how quickly that DNA evidence can be produced. On the other hand, some of the late discovery I have a little more of a problem with. But I have a problem on both sides, because John Pryor should have been a year ago going through the DA's files. He didn't do that. That doesn't relieve the prosecution of the obligation to provide discovery in a timely manner, and a timely manner doesn't necessarily mean 21 days before the trial. So I could see a judge saying, even though it's not the prosecutor's fault that new DNA was discovered and had to be processed, I'm going to give Pryor extra time to make sure that this isn't information that is exculpatory. Good questions tonight, guys. Lily, when the judge says he's taking it under advisement, does that mean he's going to speak to another judge? Nope. It means that he is going to sit down, look at all the facts, look at the applicable law, read the case law, and make a determination when he has time to think about it. Taking it under advisement means I'm going to not make a ruling from the bench. I'm not going to make a decision kind of based on what I've heard today and what I believe. I'm going to take time and think about it further and then make a ruling. And usually that involves going back and reading the statute, reading case law, looking over their notes, and making sure that they've kind of done a thorough job of understanding the evidence. But it does not mean that they consult with another judge. They could, but it's not typical, I would say. Heather, do you think Lori will take the stand in her defense? I don't think either Lori or Chad will take the stand. I would be very surprised. I would say that the Alec Murdaugh case has been a rarity in having a defendant take the stand. In my experience, I only had 2 or 3 defendants who insisted on taking the stand, and in each case, they didn't do themselves any favors. I don't think Alec Murdaugh did himself any favors either, and we're going to talk about that next hour. We've got about another 15 minutes to talk about Vallow Daybell for anybody who's still got questions, and then we'll shift over and talk about Murdaugh. Tickle Pink music. Question, my phone has been blowing up with all the court dates for Lori. Why are there dates even after the actual trial? This is a good question because a lot of people have gotten Vine notifications. Vine victim, I can't even think of the acronym right now. If somebody can think of it, you can post it. But the Vine system essentially is to notify victims of crimes, of proceedings that are going on in the defendant's case where they are victims or family members of victims. So it is not the most reliable database. There have been many times that I've gotten Vine notifications and said, that can't be right, and it isn't. So I don't take that too seriously. I don't really understand why we're getting Vine notifications for dates after the actual trial, unless potentially we are getting possible second phase dates, so dates for the sentencing portion of the trial. But I can't really explain why we are getting all these constant Vine notifications. To the best of my knowledge, there's going to be a trial that's going to start April 3rd and is going to go until it's done. And so the dates after the actual trial may be notifications having to do with potential for a sentencing phase. Don't know. I kind of usually take Vine with a grain of salt. It is created by the jail system. It is not created by the court system. And there is no real interface between the court's database and the Vine database. Somebody in the sheriff's department is taking that data potentially from the court's database, but it could be from a number of other sources and putting it in Vine. So I don't always put a lot of stock in the Vine notifications. Vine was initially created to notify victims if a defendant was being released from jail. So for instance, if you were a victim of a violent crime and your abuser or your offender was in prison for that crime, the victim would want to know if that person was being paroled early or was being furloughed or if for any other reason was being released from jail, so that they could make sure they were going to be safe. That was the whole purpose of initially of Vine. It's gotten muddied up in the process, but initially it was to notify victims so that they could make sure they were safe, or that they could appear at hearings. If a person had a parole hearing, Vine would notify the victims so the victims could come and speak at a parole hearing. Good questions tonight, guys. Hi, Carrie. Question, would it help if Kay and Larry got an attorney to assist in allowing cameras? It seems like in Idaho, you need an attorney to protect the rights of the family. I'm not sure that's entirely true, and I don't know if it would be helpful for Kay and Larry at this point. I think Kay and Larry have been more than able to express their needs to the court. They have a victim's advocate who works for the prosecution's office, who has been able to communicate their needs. I think they have been more than able to let the judge know what they need. The question is whether or not the judge is going to be persuaded by any of those arguments. And in Idaho, the judge has the ultimate decision. There is no appeal on the issue of whether or not the judge allows cameras in the courtroom. The trial court judge has the final say. If Judge Boyce says no cameras in the courtroom, there will be no cameras in the courtroom. The Koberger case, which is going on right now, is a little bit different because what's happened is the court issued a gag order, and the court judge's authority is not unlimited. The judge's authority is really limited to the people who are parties to a case. And there is nowhere in the law that allows a judge to overstep and exert their authority to people, non-parties of the case. So the judge in the Kohberger case has issued a gag order that includes the families of the victims. And there is a very serious First Amendment constitutional issue at play. And so the victims' families have hired a lawyer, and that lawyer has filed a suit in court saying to the judge, you cannot limit non-parties. That issue, a lot of the news organizations have filed amicus briefs. Amicus means friend of the court. They have filed motions to intervene as the same way I did in the Vallow case to get information as non-parties. They have filed to intervene to support the attorney who is fighting the gag order. But that is a completely different thing from the judge's determination not to allow cameras in the courtroom. Ultimately, if the Idaho judge said no cameras in the courtroom, nobody has any recourse. You can come and beg, but the decision is ultimately the trial court judges. That's not what's at play in Kohberger. What's in play in Kohberger is the issue of whether or not the judge has the authority to gag and essentially strip someone of their First Amendment right who is not a party to the case. Now, there's adequate case law that says that the judge can gag parties. I mean, that's established law, that the judge can file a gag order to gag parties and their lawyers. But there's no authority for a judge gagging and essentially stripping victims' families of their First Amendment rights. So that's a really interesting case, and it'll be interesting to see where it goes. I don't know that Kay and Larry getting an attorney would be of any help, because we know that Judge Boyce ultimately will make the decision. I don't know that he's going to be persuaded by a lawyer any more than he'll be persuaded by Larry and Kay, who are very able to express what they need. But I do think that as time is going on and we're getting closer to the trial, I do think that the judge is hearing more and more what a hardship it will be to some of the victims' families and to the citizens of Fremont County. Because remember, the citizens of Fremont County have a right to oversee their government and to be sure that their court and their government are appropriately prosecuting this case. So I think going forward, I think more and more that the judge may be persuaded. I originally said maybe a 40% chance that he'll relent. I'm tipped over to the maybe 51% that he could be persuaded. So I'm hoping that he will, because I have talked to many of the family members who say it's going to be hard for us to be able to follow the case without cameras in the courtroom. I know Heather Daybell said that. It would be very difficult for her family to be able to follow the trial if it's not televised. I'm sure that that's the case for the rest of the Daybell family, as well as the Cox family, as well as Kay and Larry and all the Woodcock family and all of the Vallow and Woodcock families in Louisiana. So I'm keeping my fingers crossed that he changes his mind. Gabrielle. Can Lori be deemed not able to stand trial after April 3rd once the case has started? Good question. If Lori were to completely decompensate and her mental condition were to deteriorate to the point where she was not able to aid and assist, the judge could suspend the trial and send her back for treatment. I think it's very unlikely. I think that although her lawyers have some real questions about her mental state, the court has found, based on evaluations, that she is competent to stand trial. So let's remember, competency is a pretty low threshold. I think it would take her completely decompensating and losing touch with reality in order for the judge to suspend the trial and send her back to be treated. And I don't expect that's going to happen. I expect that her mental health providers are making sure that she is properly supported medically. Our Venus Gal wants to know, are Lori and Chad legally married? Has there ever been proof of that? And if they are, aren't each responsible for the other's debts, etc.? Or what is the marital law if they are legally married? They are legally married. Their Hawaiian marriage certificate was presented in and was put into evidence at Chad's preliminary hearing. So yes, they are married. There is a marriage certificate from Hawaii. Somebody just posted, Vine is the victim information and notifications every day. Go figure. So thank you for that. Somebody else asked, so victims' families are parties. Victims' families are not parties to a case. Only the defendants and their lawyers are parties to the case. And in the case of someone filing a motion to intervene for some purpose, in general, those motions to intervene are for a limited purpose, such as media intervening to get documents or to be allowed to televise the case. So, but yes, Lori and Chad are married. Hi, Victoria. Do you think he's trying to keep the jury pool as clean as possible so the trial doesn't get moved? Well, certainly I think that the judge is attempting to keep the jury pool as clean as possible. But the Constitution does not guarantee that you will have a pristine jury pool. The Constitution guarantees that you will have a jury of your peers who are able to hear the evidence, apply the law, and deliberate appropriately. Jurors are asked whether they have formed an opinion, and even if they have formed an opinion, as we saw in the Murdaugh case, even if they have formed an opinion, they're asked, can you set that opinion aside? And if the information that comes out at trial is different than your opinion, can you change your opinion and apply the law and come up with a proper verdict? I don't know where they would move the trial if it were to be moved out of Boise. So I don't know what other jurisdiction. One of the reasons to move it to Boise is because of their ability to accommodate this media circus that's going to happen. So I don't think that Yes, he's trying to keep the jury pool as clean as possible, but I don't think that there would be any chance that the trial would be moved. Arwen Ferry? Question. Do you think Pryor changed his defense strategy and no longer plans to blame Lori in addition to Alex? There seems to be a difference in how he and Chad have been interacting with her lately. No, I don't think so. I think that Pryor's intention all the way along has been to say that Chad was duped by this beautiful blonde woman and that he never had any involvement at all with the murders, that he was simply a patsy, and that they're trying to frame him. And I don't think at all that theory of the case has changed. I did notice today in the hearing, when I listened to it today, yesterday's hearing, he called her Miss Vallow and then said, Vallow Daybell, excuse me, ma'am. So he's trying to be solicitous, but I wouldn't take that as he's changed his theory of the case at all. Dee Dee, do you think Vallow Daybell is as popular as the Murdaugh trial has been? I think it's possible that it will be. I think there are a lot of people who are interested in the case. I think that there are a lot of people who may not have followed the Murdaugh case as closely as a lot of us did, who were still interested in it once the trial came. So I think there's a lot of trial watchers who may not delve deeply into a case until it comes to trial, but once it comes to trial, then they're all over it. I think that was true with the Jodi Arias case as well. That there were a lot of people who, up until the time that it went, actually the trial started being televised, didn't know that much about it. But once the trial began, then people were really riveted to it. I think that's been the case with Murdaugh as well. I think that will happen with Vallow, and I think you're going to see a lot of people who had not previously gotten deep into it suddenly be Vallow Daybell watchers. Let's take one more Vallow Daybell question, if there's one more out there, and then we're going to move on to Murdaugh. Hi, Lee here. Do we know if their families are still supporting them, i.e. Chad's kids, and any of them visiting them in jail? As far as we know, Chad's children are still supporting him. They're still, the ones who are local here are still visiting him in jail. I understand from a source that he has photographs of Tammy and his children in his jail cell, and not a single one of Lori. And as far as we know, they are still supporting him and still visiting him. I think you will see them arrayed in the courtroom behind him the whole time. Murdaugh time, boss, one of my mods just said. So let's talk about Alec Murdaugh, and let's talk about this juicy examination and cross-examination. It was very clear from the outset that Alec's attorneys did not want him to testify. And that is probably, that would have probably been true no matter who he was and no matter what he was charged with. His lawyers would have discouraged him from testifying. Once a defendant gets on the stand, they waive their Fifth Amendment right against self-incrimination. You can't get on the stand and say, I'm here to tell the truth, the whole truth, and then say, oh, but I'm going to invoke the Fifth because I don't want to answer that particular question. Doesn't work that way. It's all or nothing. The other thing is that unlike regular direct witnesses, The other side is given broad discretion on what to cross-examine that person about. In general, when you call a witness, let's say prosecution calls a witness and the defense then gets up and cross-examines that witness. The defense is limited to only the subjects that were raised on direct questioning. So if the prosecution puts on a witness to talk about, I'm trying to think, let's say Maggie's sister, and puts that witness on to talk about what a great person Maggie was and how much she's missed and all of those things, the defense can't then come in and say, yes, but isn't it true that you were with Maggie when she went to see a divorce lawyer? Well, no, because the prosecution didn't bring that up. Now, there's been a lot of rumors that Maggie was contemplating divorce or that she had seen a divorce lawyer. I'm not sure that's true. I've seen no evidence of it. Nobody's ever been able to produce it. I think it's possible that she was concerned about the money because, let's face it, Maggie was a woman who had a very traditional relationship with her husband. He was the provider. She was the housekeeper, the homemaker. She was the mother of the children, responsible for raising the children. It was a very traditional relationship. Maggie was not in a position to be able to dictate what Alec was doing and wasn't in a position to make demands. Her lifestyle and her social standing depended on him. So it was interesting. Let's not go off on that tangent, because the defendant is on the stand, then the prosecution has wide discretion in cross-examining him. So they didn't have to wait for the defense to open the door, as we've seen in a couple of other defendants. They didn't have, or witnesses, they didn't have to wait for the defense to open the door. They were able to launch right in and bring up things that the defense had not raised on their direct examination. So then we have the defense sort of delving into a lot of different things that in general you would have thought maybe are muddying the waters a little bit. One of those things was all of the financial crimes. But we know that in a big way, they were kind of enmeshed. The financial crimes, the prosecution alleges that the financial crimes were at least in part Murdaugh's motivation for committing the crimes. I think there were a variety of motivations for the crimes, and I heard a couple of things today that I got my antenna up. One thing I heard was, first of all, we have Alec, who has a 20-year opioid addiction. We finally heard how that happened. He hurt his knee when he was playing football in college and had a long time painful knee injury, had a couple surgeries, and so had this kind of ongoing issue that then led to him needing more and more opioids in order to feed his habit. So we had that. We had his ongoing financial issues. I thought it was interesting that he talked about the fact that he was under a lot of financial pressure because prior to the recession in 2007 and 8, he got involved in a couple of land deals where they were buying property and flipping it and making money. But when the recession hit, then nobody had any money to pay the payments on all of the loans they had outstanding on those properties. And so he got stuck making enormous payments on these big property deals. However, I don't think that was the complete impetus for his beginning to steal, because I think some of those thefts predated those bad land deals. But we do have him continuing to steal from his clients, stealing from his law partners, and it's as if that gets to a critical mass. And the critical mass is when he takes fees that should have been paid to the law firm for himself. He tells his best friend, Chris Wilson, that he has permission from the firm to do this and to structure these fees so that they can be protected from the boat crash litigation, from the boat crash civil suit. And in reality, his firm has said, we want no part of helping you hide anything from the boat crash litigation. That would be improper, unethical, and illegal. And they had not given him permission to take this money. It was a lot of money, $792,000. It also was clear that he got that money and he very quickly blew through it. $500,000 of it went to Curtis Eddie Smith. He testified today that that was for drugs. I don't believe that. I don't believe that he gave Curtis Eddie Smith $500,000 for OxyContin. Nobody can, I mean, he was talking about a $50,000 a week habit. Nobody can maintain a $50,000 a week habit. I mean, he was at the levels that he testified he was taking them. He was sort of right on the edge of killing himself with those doses. Although we know that people build up a tolerance and that someone who has been using for an extended period of time has a much higher tolerance than someone who's just starting out. But $500,000 of that went to Curtis Eddie Smith. Why? So that's another pressure. We don't know what was going on there, but there are additional pressures there. He's in the middle of this boat litigation with his son. His son has been criminally charged in the boat litigation. He has convinced his family that Paul was not driving the boat. Maggie is absolutely convinced that Paul was not driving the boat, in spite of the fact that every other witness from the boat said Paul was driving, and he was highly, highly intoxicated. So Maggie is convinced she wants Alec to fix this for her baby boy. Now, this is a family who is notorious for fixing stuff for their kids, getting their kids out of trouble. We know that the night of the boat crash, Alec and his father, Randolph, were both at the hospital. Alec is there, as Creighton Waters points out, with his solicitor's badge hanging out of his pocket, going around from room to room, and he is telling the witnesses that Paul wasn't driving the boat. He is going around and he is strong-arming witnesses and telling them to say Paul wasn't driving the boat. He's going around and telling everybody Connor Cook, who was one of Paul's friends, was driving the boat. And he is laying this entire disaster on an innocent kid. So we know that that pressure was coming up. But there's some other stuff that came up out of testimony that I thought was very interesting. So Alec says that while he is, can't remember, Maggie at some point was alone with Alec's computer bag and started looking through his computer bag and discovered a bag of pills. Now, Alec has been telling Maggie, I'm going to stop, I'm going to stop, I'm going to stop. he testified he's tried to detox on his own. He's been to detox a couple of different times. But remember, as he testified, detox was 7 days long. So it was easy for him to tell his associates, tell his law partners, I'm going to take a week off and go to detox. It's not easy to tell your partners, I need to go to rehab for 90 days or 120 days. That's harder to hide. So he's been to detox a couple of times. Maggie finds the pills. He has a long talk with Paul. And in that talk, he assures Paul when the boat crash thing is all over, he will go to rehab. Now, promising Paul that he will go to rehab means that he will have to out himself to his firm. That is going to raise some big concerns and some red flags in the firm. There's already some red flags going on about questionable transactions. So add into that, oh boy, we have a partner who for a long time has been addicted to opiates and we didn't know it. What's our liability? They're going to be going back through their cases wanting to know whether or not it impacted how he tried cases. They're going to be going back through their financial records trying to figure out whether it impacted his financial dealings with the firm. That's going to set off a huge earthquake. So I think that he was in deep with Curtis Eddie Smith, who we know was in some way involved in some of the drug and gang sort of activity in the area. It is very possible that Alec was more deeply involved in the dealing and selling of drugs. It is very possible that he was trying to, I mean, there are a number of reasons. Let's say Curtis Eddie Smith gets himself sideways with the cowboys who are the drug guys, and he owes them money. Well, he's Alec's supplier. So what happens? Alec bails him out of whatever trouble he's in with the cowboys. Doesn't necessarily mean that Alec is directly involved with dealing or selling drugs, but it is possible that he was bailing Cousin Eddie out because Eddie was his source and he didn't want to burn his source. He wanted to keep his source giving the pipeline to his supply open. So there's a number of reasons why Elliot could be giving Eddie money that wouldn't necessarily mean that he was directly involved in the drug dealing. However, so we have him promising Paul that he's going to go to rehab. We have Maggie breathing down his neck because she's kind of starting to get suspicious that something's going on. Because he goes to her and says, I need to refinance Moselle and Edisto. These are the two homes they own. Maggie, he had transferred Moselle into Maggie's name only. Maggie didn't like to go to Moselle. It was dirty. It was hot. There were too many bugs. She liked being at the beach. The beach was a more cultured atmosphere. Moselle was sort of the good old boys chewing tobacco and hunting hogs. Maggie was a girly girl, so not her cup of tea. So, but he goes to her and says, you have to sign off on this refinance, and I need to get this money out of Moselle. He's trying to get the money to pay back into Chris Wilson's trust account before the firm discovers it's missing. He keeps telling everybody, oh, I didn't take that money. It's still in Chris Wilson's trust account. And in fact, it had already been paid to him. So now he's got to quick put $792,000 back in Chris Wilson's account. in his trust account. So he's trying to get money from refinance. He's borrowed money from his partner. He's borrowed money from as much as he can from Palmetto State Bank, and he's still short. So he's got to get this property refinanced. He's trying to get an appraiser out there, and Maggie's not cooperating. She's busy. She doesn't want to show up. Because she doesn't really want all this property encumbered. She doesn't really understand what's going on. So Maggie's standing in the way of him being able to work his little shell game and get this money paid back. I think that it was a variety of things going on. I don't think that it was one thing. I don't think it was just the financial pressures. I think it was Paul putting pressure on him to go to rehab. I think it was Maggie getting suspicious about the financial dealings. I think it was pressure and his firm getting suspicious. I think that it was all like this, the walls were just closing in on him. And I think that because he is very likely a sociopath, he saw this as the only way out of what was happening to him. I also think we heard some really interesting testimony today that made me rethink what happened on that night. I thought we've known for quite a long time that Paul made a video down at the kennels and Alec could be heard on the video. Alec didn't know Paul was making a video, and he lied about being down there at the kennels. He lied over and over again about that. He had to go on the stand yesterday and admit that that was him on the video and he had been there. Now, if the prosecutor's timing is right, that puts him at the scene within 5 minutes of the murders. And yet, so his testimony was, well, it was hot. I'd been out with Paul all day or for a while riding around and I was hot and I was sweaty. I was overweight. I was taking opioids. So I went home. I took a shower. I got cleaned up. I was in the air-conditioned house. Maggie said, come down to the kennels with me. And I said, no, I don't want to go. He also said on one of his police interviews, Paul left and I don't know where he went. Later on today in his testimony, he admitted, yes, Maggie and Paul went down to the kennels together, and I then changed my mind about going down there, and I drove down there in a golf cart. That's when the light bulb went on for me. And all along, the prosecution's theory is that Paul was killed first. I think they have it backwards, because I think now, thinking about it and thinking about the diagrams and everything else, Alec came down in the golf cart. Maggie was outside of the kennel area, and he shot her. And when Paul heard that, he was afraid. He stepped back deeper into the feed room, which we heard the people who were reconstructing the scene say. He stepped back deeper into the feed room, kind of fearfully. His dad came to the door, shot him in the chest. When he moved towards his dad in the doorway, he shot him for the second time. It makes sense because we heard all that testimony about how the 12-year-old or the 5'2" person is the person who shot Maggie. I think Alec was still sitting in the golf cart at the time he shot her. And then he got out of the golf cart. I think he used two guns because he hoped that it would muddy the waters and people would think there were two shooters if he used two different guns. And I think he was sitting in the golf cart. He shot Maggie. He went toward the feed room because he knew that Paul was there. Paul was in the feed room, and had it not been somebody who knew he was there, he may not have, they wouldn't have known he was there to shoot him. They would have just shot Maggie. He was not in the line of sight. He was in this dog food room. So it makes some sense to me at this point that that's what happened. He then very quickly went back up to the house. I think, frankly, I think the reason the hose was unwound is because he hosed himself off there at the dog kennels, and then he drove the golf cart back up quickly, changed his clothes, threw the clothes into some sort of a container, and went to his mother's house. He took the guns, he took his clothes, went to his mother's house, hid those. There were several outbuildings on the property, hid those things in an outbuilding, went back later and disposed of them, which is why they are nowhere to be found. But I do think that scenario kind of fell into place for me today as I listened to his testimony. So let's take some questions and find out what y'all think. Y'all, you can tell I've been listening to the Murdaugh case for too long. Hi, Jen. Jen, thank you so much for your generous donation. Everybody has been so generous tonight, and I appreciate it. I know our mods do, so thanks. Sorry if I've already answered this. Have you seen the Fitz News interview with Lindsay Edward? She was trafficked to him and he nearly unalived her multiple times. If she is truthful, he has been a sadist all along. You know, this is hard. We never, ever want to disbelieve a victim like this. And it may be true, but it may be not true. We've heard a lot from human trafficking victims, and I've worked with several young women who had been trafficked, even in rural Oregon. So it is very possible. I don't know enough. I have not seen the Fitz News interview, but now that you ask, I will go back and find it and watch it. I don't know enough about Lindsay Edward and the situation. I can't discount it because I would never discount a victim's experience, but I don't think we probably know enough. I have never heard anything else that would lead me to believe that Alec had those kind of tendencies. We've heard a rumor that there was an affair or two out there, but we don't know what people get up to in private. And we know that at least there is a history in recent years of rich, powerful men taking advantage of young, helpless women. So I don't know what to make of that, but I will look for it and I'll let you know what I think once I've had the opportunity to look at it. So thanks for asking that. I admit that I have not been following carefully anybody other than Mandy Matney and her gang, and most of that's been on Twitter since the trial started. So I haven't looked at a lot of in-depth stuff since the trial started. Do I think he's guilty? Yeah, I think he is. And I guess for the reason most people think, who else could it have been? He was literally there 5 minutes before they were murdered. And there's no indication that anybody else was on the property. He testified today. No, I was down there 5 minutes before they supposedly were murdered. And he was asked, "Did you see anybody suspicious? Did the dogs bark like there was somebody around that was unfamiliar? Did it?" No, no. Mm-mm. Which I thought was kind of damning evidence coming from Alec. He was there. He's the only person left alive who was there that night. He was there within 5 minutes of their murder, and there's no indication that there was anyone else on the property waiting to ambush them. No indication um, of any other threat. So I think for that reason alone, I think he's guilty. Mary Sorrow. Wouldn't Alex produce the missing clothes and shoes if there was no blood on them? I agree. I think that's a great observation, and I think that it was a great question. During the trial, Creighton Waters asked him, "Did you ever offer to produce those clothing? That clothing?" "No, I didn't." Um, so I think, yeah. I mean, if it were me, and somebody handed me a picture and said, "Where are these clothes?" I'd say, "Oh, wait a minute, let me get them for you." But I think he couldn't produce it because he couldn't produce them because they were disposed of. Gail Johnson. If Alex gets off on the murder charge, I'm assuming what you're saying, how sure are we that he's going down for life? Now, I'm not a South Carolina lawyer. Don't even play one on TV. So I'm not an expert. My understanding is that the charges that he is facing for the financial crimes, in total, he could be sentenced to life without parole. Um, but I'm like I say, I'm taking that from what I've read and heard. I'm not an expert. So I do believe that they're pretty confident that he'll be in prison for the rest of his life. I think that Creighton Waters did a pretty masterful job of laying the foundation for those crimes. Remember that anything that you say in sworn testimony can be used against you. So every one of those admissions that Alec made on the stand, he under oath, can be used directly against him in the financial crimes. Now, yes, he previously had made some admissions, but to do it on the stand in court pretty much seals your fate. So I don't think there's any question at this point that he's going to be convicted of all of those financial crimes. So I'm from what I understand, um, the prosecution is fairly confident that he's going to be in prison for the rest of his life on the financial crimes, even if he's not convicted on the murders. I think that there's at least a possibility. Oh, you can go ahead and put that question up. I think that there is at least a possibility that we may get a hung jury. That's what makes me most nervous. Not a not guilty. I think that we're looking at a guilty or a hung jury, but it only takes one juror. And I heard from Gigi from Pretty Lies and Alibis. She has been in the courtroom for Law and Crime Network. And she said there were a couple of jurors in tears while Alec was testifying. Bo Peep. Question: do you think that Maggie's will was changed by Randy and John Marvin from her sister to be executor to John Marvin being executor? I doubt it. I doubt that. But I don't know why Maggie changed the executor. It could have something to do with an agreement she had with John Marvin and Randy on how they would take care of her boys. I think that following the boat crash and It's what 2 hours does. Getting tired, but I think that what one of the results of the boat crash and the issue of Paul getting threats and all of those sort of things was probably a heightened awareness about what would happen if something happened to me. I think that's kind of natural. I don't think that Maggie ever anticipated that Alec was going to kill her, but I think that it's sort of natural to say, ooh, if there are bad guys out there and they really are after somebody in our family, what would happen if something happened to me? So I think that's kind of a natural thing. And it may have been at that point that she changed executors. I mean, if you're going to change Maggie's will, changing the executors, the smallest thing you would change. I mean, why go to all that trouble? The executor is a fiduciary who has to act in the best interest of the estate. They have to do what the will says, regardless of who they are. So changing the executor to me isn't all that suspicious. Do I think the prosecution did a good cross-examination? For the most part, yes, I do. I think that there were times that Creighton got a little frustrated and he allowed Alec to get more control over this conversation than he probably should have. I think that's human nature. I also think that there were times that Creighton got too far in the weeds, but I understood why he was doing it. He was doing it so that he could finish with that litany of people who Alec had lied to, with that litany of people who he cared about and lied to. And I cannot imagine a closing argument from Creighton that isn't going to start out with Alec Murdaugh could lie and cheat and steal and hurt the people he loved, because it came right out of his mouth. I loved these people and I stole from them and I hurt them. And that has got to be where Creighton Waters starts. He is capable of hurting the people he loves most. He was capable of bilking his law partners, who were like his brothers, of millions of dollars and leaving them holding the bag. He was capable of betraying his best friend. He was capable of hurting the people he loved. Where did it end? Where did his ability to hurt the people he loved end? Well, it ended on June 7th when he brutally murdered his wife and his son. I think that's where Creighton has to go with it. And so I'm not sure that he could have made that kind of a closing argument had he not really pecked away at the details in his cross-examination. So yeah, I think that there were a lot of people who were like, okay, with the financial stuff, remember, we're here for murder. But I did understand that he was kind of building that foundation brick by brick by brick, very methodically, so that he could get to the end of the cross-examination and say, you lied to this person, you lied to that person, you lied to this person, and elicit from Alec, yes, I betrayed and lied to all the people, to all these people, including people I cared deeply about, people I loved. And I think that's how Creighton bridges the gap to saying, how do we jump from financial crimes and betrayal to murder? I think that's how he does it. So, yeah, I mean, I think every lawyer has a little bit different style. I think that Creighton did a good job of using some really kind of tried and true techniques. Let's see what we can agree on. Can you agree this? Can you agree that? Those are very, very typical cross-examination techniques. And I think in general, he did a pretty good job. I think there were times he got a little frustrated with Alec, or he gave up a little too much ground, and let Alec get control. And it's clear Alec's a trial lawyer, and I thought he did a really good job on the stand. I thought that it was hard for Creighton to rattle him. I felt like there were a lot of times when someone who wasn't that accomplished in court would have been a lot more rattled. So I think they both did a good job. I don't know that Alec's decision to testify helped him. I think in many ways it hurt him, looking Creighton in the eye and saying, yeah, I hurt a lot of people I love. Well, if you're capable of that, how far will you go? So, great questions tonight. How much, if any, access to media and internet do inmates have, both in South Carolina and Idaho? Nana, thank you. Limited. I think you heard Alex say, we don't get to watch the news. Everything's very limited. In Idaho, my understanding is, at least on Lori Vallow's side, on the women's side, that they have access to iPads or some sort of electronic pad, and that they are able to perhaps send and receive messages through there. Remember, though, that they are through a secure system. So there is this company called Telmate, and they are the people who really handle all of inmate communication for most jails and prisons. So, for instance, they have video kiosks set up in the prisons, but you pay for them. So somebody has to put money on your book so you can pay to have a video chat with your family, just like you would pay to have a telephone call with your family, or to send text messages to your family. So, and those people who you can communicate with have to be on your list. And so they don't have a lot of access to media and the internet, except through very limited and very closely monitored sources. I don't think they get the opportunity to watch the weekly news. I don't know that they get a lot of that. They are able to receive and send written letters, but every one of those is opened and monitored. They can be censored. The jail can refuse to deliver them. So, and anyone who is pre-trial, all of that communication is subject to being recorded and turned over to the prosecutor. So it's pretty limited. I think Lori and Chad probably can communicate by letter, but everything they write back and forth to one another is monitored by the jail, and anything that's even limited suspicions turned over to the prosecution. So. Venus Gal, did anyone catch today when he said Maggie asked him to leave and then he corrected himself? Yeah, I did. Yeah. I mean, there's been a lot of conversation about the fact that that potentially there were issues between Maggie and Alec. And how could there not be? I mean, let's be realistic. How could there not be? He was an opium addict. He was an opiate addict. And regardless of what he said about, how it energized him and all of those things, there's no question that a lengthy and deep drug addiction changes a person's personality. And there's no question that it makes a person, their behavior erratic. So how could it not have caused problems between them? I think that was another place where he probably was pretty dishonest in saying, no, we had a wonderful marriage. Well, I'm sorry. No long-term marriage is ever perfect all the time, and there are always bumps in the road. And um, I think it's very likely that there were continuing problems going on. She was frustrated with the fact that he couldn't kick this pill addiction. She was terrified that they were going to lose everything because of the boat wreck. She was worried about Paul having swollen ankles and and high blood pressure. I mean, she had a lot on her plate. She was worried about remodeling her beach house. I mean, there were a lot of things going on for her, and I think, how could she not? There not have been problems in marriage. Do I think they were on the verge of divorce? Probably not, but certainly I think there were problems, and I think that was sort of an inadvertent admission that. There were other indications. I mean, there's a text message that she sends to her sister that says he's up to something, and I don't know what it is, and he wants me to come back. And I think she spent more time at the beach house because it was easier. Michael Haxby. Question: do you have any inside info on the new misdemeanor charges that were allegedly filed today against Alex? No, in fact, I hadn't heard anything about them. Um, so I don't know what the basis is. I know that there was an ongoing investigation into his interference in the boat crash investigation. So I don't know if maybe they stem from that. But he made a lot of admissions on the stand that could open him up to new charges. So now you made me curious. I'm going to have to go look. Mary Sorrow. Question: did anyone notice Alex admitted his financial crimes but never expressed any regret? He was like, yeah, I did it. So what? Yeah. Yeah. Certainly, I think everyone noticed that. And it was all over Twitter today. It's certainly, I mean, I think that Creighton Waters kept trying to get him to, the closest he would say was, I stole from people who I care about and who I loved. And in some cases, they were people I loved. But I don't, he never did express any remorse. Creighton Waters really tried to get him, particularly when it came to Gloria Satterfield and her children, to try and get him to express some remorse over it. I mean, if you're not remorseful, your housekeeper who has literally raised your children. I mean, we're talking about someone who had probably spent more time with Paul and Buster Murdaugh than she spent with her own children. This person who has really raised your children, who knows where you keep your laundry, who has been there and cooked your meals and been in your home and taken care of your children, falls over your dogs on the front porch, and your seeming remorse is, I'm going to connect you up with a friend of mine. I think you should sue my homeowner's insurance and my umbrella policy because you boys are going to need some help. These are two young men, one of whom, his brother testified at trial, is a vulnerable adult. I would submit that Tony's a vulnerable adult too. He's certainly more functional than his brother, but he's a vulnerable adult too. Just, you can tell from his testimony. And yet Alec never said, I'm sorry for that. I regret doing that. He would say, it's wrong, and I did it, and I did wrong, but he never really did express regret or say, I'm sorry, I hurt people I loved. He went as far as to say, I hurt people, many of whom I loved, but he didn't make the next jump and say, and I regret it, and I'm sorry. He never did that. I don't know if that was a decision that was made by he and his counsel, or whether that's just who he is. But I think it was he missed an opportunity. And at every turn he'd say, well, yeah, I don't know whether I looked him in the eye I don't know if I talked about this particular disbursement sheet. I don't know if I looked him in the eye, but I think those are small distinctions when it comes to bilking people out of millions of dollars, vulnerable people out of millions of dollars. So, good question. How many more witnesses do you think the defense will call? I think, well, I think that was an interesting tactic too, which I think that Jim Griffin said they had these other two expert witnesses. I think maybe 2 or 3 more witnesses, and I think they'll wrap up. And it was very interesting because Jim Griffin raised to the court before they put they put Alec on the stand, and when they got to the cross-examination where Creighton Waters was going to start his cross, the defense asked if they could take a couple of their witnesses out of order because they had these 2 expert witnesses who had flown in to testify. And if they didn't testify, they were going to have to hold them over the weekend, and it was going to be expensive. Creighton Waters said, I've tried to be accommodating, but I don't want to interrupt my cross-examination. This is like throwing off your rhythm. I think they did it purposefully, hoping that they could get the judge to let them do it and it would throw Creighton off. The judge didn't fall for it and said, no, you don't get to interrupt. You put Alec on, and now we need to get through the cross-examination. But I did think it was interesting that the cross went long enough into Friday that by the time they were finished with their direct, they didn't have time to put those experts on. These are, I will remind you, also the attorneys who have been renting a $20,000 a week venue that holds weddings to hold up and do all of their trial preparation. So I'm not too sad for them, but I thought it was kind of amusing on Creighton Waters' part to make sure that they had to keep those experts over the weekend. Gail Swift Fernandez. It was a recorded telephone conversation. Not sure what that refers to. Recorded telephone. Do you think someone helped him get rid of the evidence? No, I don't think so. I don't think so, but I do think, and I continue to think, that when you have someone who is white, who's got generational wealth, who is prominent and connected, even though he didn't like that word, in the community, who is known to law enforcement because his father was the solicitor for 30 years, which is the prosecutor, and is known to law enforcement. This person who is also known that you don't cross him and that you never want to be indebted to him or his family. When law enforcement shows up to investigate a case, they are going to give him all kinds of deference. I was appalled when he testified. I don't know if it was Ellick or it was somebody else testified that when the SLED investigator came to the home with a search warrant to search the Moselle house, and it was full of people. It was full of all of his lawyers. I mean, the place was full of lawyers. When they got there, the first thing she did was offer to take off her gun belt and all of her identifying uniform parts. Why would a police officer do that? That's crazy. That's deferential. That is, I'm deferring to this power base that is standing in the gun room or in the family room while I go around the house and do this investigation. So were they thorough? Probably not. Did they do the best possible investigation? Probably not. Did they let Alec and all of his lawyer friends walk around and perhaps walk through the scene? Probably. Because they were dealing with this huge power imbalance, this big imbalance of power between the law enforcement people that were there and these very prominent, powerful white people. So I don't know that anybody helped him get rid of the evidence, but I don't know that anybody really dug very deeply into the scenes very quickly. We know that they didn't search Almeda, his parents' place, until much later. So he had plenty of time to go get rid of that stuff. So my opinion is he took it all to Almeda. He hid it in one of the outbuildings, which was right next to where he parked his truck. He went in and saw Mama for a few minutes, and he went back to Moselle, where he discovered the bodies and called 911. We're almost at the 2-hour mark, so let's take a couple more questions and about the Murdaugh case, and then we'll wrap up for the night. I'm sure there's going to be a lot more to talk about on Wednesday for True Crime Wednesday, and we'll meet there. I encourage you, please, my email is in the show notes. If you have other questions that we didn't get to, email me, because I answer every email and I will certainly answer yours. Also, Saturday mornings, I get my cup of coffee out and I read all the comments and the chats from the night before. So tomorrow morning, I'll be taking a look at all the comments. So if you have questions we don't get to, post them in the comments and we will get to them. I want to thank everybody for being here with us. 2 hours on a Friday night is a lot. There are 400 people in our chat tonight, so thanks so much. If you haven't subscribed, please do. If you haven't, hit the like button. That helps with the algorithm. More importantly, please get notifications, because as the Vallow trial gets closer, we're going to be putting up content anytime anything exciting happens. And during the trial, I will be posting YouTube shorts as frequently as I can. So, like and subscribe. Join us for I always do this backwards, the quilt, the True Crime Quilt Guild, and please tell your friends about it. Tell your friends about the podcast and share it on. Marie Paul, does anyone think Alex is so willing to fess up to the thefts to try to create the lesser of two evils in hopes of diminishing the murder charges in people's minds? You know, that's an interesting question. The law generally says that you can't bring in character evidence merely to prove that a person acted in conformance with their character. So for example, you can't say someone who has been accused of a robbery, you can't say, well, they they stole their grandma's wedding ring, so that must mean that they're a bad person and they must have committed this robbery. So you can't use that evidence to prove character, but you can use it to prove motive, state of mind, plan, kinds of all those kinds of things. So I don't know whether it helped him or hurt him. Fessing up to the thefts, maybe to say, just because I'm a thief doesn't mean I'm a murderer. So I think that may be their argument. Just because I'm a thief, I'm not a murderer. There's a difference. And I think that's where they may go with that. Um, I think that it was a way of maybe inoculating the public. You know, Alec's not a great guy. He doesn't have great character, but that doesn't mean he murdered his wife. So maybe in some ways it was a way of sort of inoculating them to the idea that he's a bad guy. I mean, I think if you take this person who is a lawyer, an assistant solicitor, that he's from this very wealthy, very prominent family of lawyers, and we take this big jump to he murdered his family. Maybe it's easier to say, well, maybe he wasn't the guy we thought he was because he did all these financial crimes. So maybe he wasn't the guy we thought he was when it comes to whether or not he murdered his family. I'm not sure it helps him. I think in many ways it hurts him. But good question. This is on the jail website. Warrant misdemeanor arrest. Well, that's interesting. And it's clear that they've issued a misdemeanor arrest warrant. Who knows what it's for? Because we're not seeing an indictment, but it's definitely something to look into. You know, who knows? It could be misusing his commissary while he's been in jail. We know he's been gambling and using it to bet and using it to encourage people to make phone calls for him and those sorts of things. So, I mean, who knows? Or it could be some admission that's come out of his yesterday and today's testimony. It's interesting that it was only issued today. So it'll be interesting to see. Let's take one last question. While we're doing that, I once again want to thank everybody for the super chats. We also have a PayPal link in our show notes in case you'd rather donate that way. I appreciate it because all of that goes to our moderators. And I noticed tonight that there have been a lot of them and you've been very generous. So I want to thank you for that because I have the best mods in the world and they deserve it. So Victoria, we need to get together for coffee. Victoria lives in the Boyce area. Is the prosecution someone Alec Murdaugh has gone up against in court? That's a good question. I don't think so. The reason is because Alec did primarily civil work. And so he wouldn't have necessarily gone up against a prosecutor because he didn't do criminal defense work. And but I thought it was interesting that Creighton mentioned that Creighton was 2 years behind him in law school, but Alec didn't know him. And I thought the undercurrent to that was, well, I wasn't important enough for you to know me when we were in law school together. Now, to be fair, it is not at all unusual for someone to be a third-year law student and not know any of the first-year law students. In fact, it's more typical than unusual. So, but I just thought it was just kind of a little dig that, you know, we went to law school together and you don't even remember me. So, but I don't think that Alec would have come up against Creighton or any of the prosecution lawyers because he just didn't do that kind of law. Once again, I want to thank everybody for spending your Friday night with me. You don't know how much I appreciate it. And I know that there are so many other things that you could be doing. So I just want to thank all of you for joining us tonight. Over 400 people in chat with us on a Friday night. That's amazing. So join us Wednesday night when we're going to have more to talk about on the Murdaugh case. Thank you, Michelle. Thanks for everyone having joining us and being here tonight. Thank you, Michelle and Brenda, for always being ready and willing to stick around for an extra hour. And we will see you all on Wednesday for True Crime Wednesday, when I'm sure that we will have way more to talk about, particularly with the Murdaugh case. And potentially, we may have some answers in the Vallow case as well from the hearing on Tuesday. So stick with us. Join us then. Until then, I'm going to say good night.